Let's get Dan Schorr in on this. Dan, big win early in the day for the prosecution to get that in there, and did they capitalize on it in full?
It was a win, but it doesn't really amount to much. Whether or not he studied criminal justice and wanted to be a police officer really doesn't amount to anything when you're looking at whether he used justifiable self-defense when he says he was being attacked by Trayvon Martin. And for all this talk about the stand your ground law, really doesn't mean anything in this case in the end, because stand your ground law is about whether you have an opportunity to retreat and whether you have to take that opportunity if you have that. But George Zimmerman's version of events is that he was underneath Trayvon Martin, his head was being pummeled into the concrete, and that's why he used his weapon. So this really is not about stand your ground, it's about justifiable self-defense. And I don't think any of this helped the prosecution, although it was a win for them that they got to introduce it.
Got it. Well, you mentioned stand your ground. Gene, Dan, let's listen to George Zimmerman and his interview. We're going to backtrack to his interview with Sean Hannity, because Sean Hannity asked him about stand your ground. Was he familiar with it? Here's what George Zimmerman said. And keep in mind, he took a class where they covered that topic. So let's listen.
A lot of this case legally has to do with stand your ground. You've heard a lot about it. And I was just curious, prior to this night, this incident, had you even heard stand your ground? No, sir. You'd never heard about it before? Wow.
Gene Casares, does the prosecution replay the Sean Hannity interview at some point to show an inconsistency? And if you're the defense, how do you explain that?
They'll argue it in the end, and now they have it, so they can do it because they got in today. I think that is one of the biggest wins for the prosecutor today, because he definitely says, you can see, I don't know anything about stand your ground, but his professor went on and on today about how he wanted to bring the laws to life, and he wanted to bring to the students laws that were applicable to their life, and stand your ground was here in the state of Florida, and he really focused a lot of the course material on that. It wasn't in the book, but he said it was in the course presentation.
Dan, is that damaging to Zimmerman's defense?
Well, it certainly shows an inconsistency. It's odd how it was introduced here, because usually you show inconsistencies after someone testifies and then you go after their credibility by showing that they've said other things. Here, the defendant hasn't testified and very likely never will. They introduced a statement of his to Sean Hannity and then introduced this professor to show that part of that statement was incomplete or incorrect. It does show some kind of inconsistency on George Zimmerman's part, but does it really prove beyond a reasonable doubt that he didn't use justification and self-defense? I don't think so. It seems like a small point. Yes, they could argue it in closing arguments, but they have a long way to go to get a conviction here, and I don't think it really helps them very much.
Got it. I'm sure something the jury could discuss in that jury room when the time comes. Well, let's get our expert in on this. What we see as a legal maneuver. Attorney Dan Schorr's with us. Dan, what about what Don West did there? Okay, so the prosecution wins, and you laid it out there, that the jury hears, okay, George Zimmerman took some criminal justice classes, this on criminal litigation. Then he spins it to use Mr. Alexis Carter to begin to give the jury a tutorial on self-defense, and really gives hypotheticals that relate to this case.
Right, we've seen this with a number of witnesses where the prosecution offered a witness and the defense turned the person into their witness in some respect. I was very surprised this cross-examination was allowed, though. Usually the judge is the only person explaining the law to the jury, and the facts come in through witnesses, and the judges are very strict about not having witnesses or lawyers instruct the jury on what the law is. That's for the judge at the end of the case. So to allow a witness to come in, take the stand, and explain to the jury the law of self-defense, which they're going to have to use later when they're judging guilt or innocence here, that was very surprising, and I think most judges would not have allowed that.
What were you thinking as it was going on? Did you think, wow, these are big points for the defense, because this guy's almost laying out what could have been going on in George Zimmerman's mind?
Exactly. When you have the defense attorney able to use a prosecution witness to explain the law to the jury and spin it, or at least use hypotheticals that are consistent with the defense theory of the case, that's very helpful. Remember, we're still on the prosecution's case. This is supposed to be the point where they're winning, where they're making their big point, and we've seen with numerous witnesses here that the defense ends up using the witnesses to help their side. And if it keeps going like this, we may not see much of a defense case put on, if any, at all.
Okay, let's get back to where the prosecution was trying to go with the wannabe cop theme. They get out there, he's taking criminal justice classes, he goes on a ride-along. Where does that become negative, where a juror is seeing wannabe cop? Dan?
Right. Most people see someone who wants to be a cop and think that's a good thing. It's noble. What they're trying to say here is that he was overzealous, that he was obsessed with being a part of law enforcement. He wasn't able to be a cop, so he took it upon himself to do this neighborhood watch program, and that he was following Trayvon Martin in an inappropriate manner. And their theory of the case is that he took it too far, attacked Trayvon Martin because he wanted to stop him. He was too suspicious, too overzealous, and that he initiated this confrontation. So they say that his interest in being a cop and his studies about criminal justice, that's consistent with this personality. But the flip side is, it's a good thing. He was a good student, according to this professor. He wanted to be a police officer, which is a very noble profession. So it's probably not going to help the prosecution that much.
Got it. Okay, and that's what we do here at HLN. We give you both sides of the points that are being fought out in court. More from Dan, and again, more testimony coming up, we expect within the next 10 minutes in this case.